All right, welcome everyone to the last session of the day, our fifth keynote from Solon Barocas, who is a researcher with Microsoft as well as with Cornell University. And Solon is undoubtedly a leader, one of the main leaders of research in fair AI, unbiased AI, bias mitigation techniques, ethical AI. Some of you may have noticed the Journal of Responsible Computing, ACM Journal, just put out a call for papers of discussions of Solon's recent book, the very well-known Fairness in Machine Learning, which just came out with MIT, but has been available online for some years. And I'm very excited that he agreed to join us today. He's one of my personal heroes in terms of the work that he's done, and I'm very happy to have him here with us today to share some cutting-edge research on less discriminatory algorithms. And I'll turn it over to Solon.
Well, thanks very much. I'm really pleased to be here. I also appreciate people sticking around. It's been a very full and engaging day. It's really also an honor to be here. I've been involved and work in this area for more than 10 years now, and so it's been very exciting to kind of see the field develop and to also see it being taken up in these kinds of ambitious institutional initiatives. So I'm in particular really happy to support the work that's happening here at Morgan. I should also say that I kind of have an odd background. So even though a lot of my work is with computer scientists and lawyers, and in fact, the co-authors on this paper that I'm about to present are in fact a mix of computer scientists and some more law and policy types, I'm neither a computer scientist nor a lawyer. I kind of just have figured out how to work across these fields and, oops, did I do something? Let's see. No? Oh, okay, on my screen something is changing, but hopefully that is not a problem, sorry. In particular, what I've tried to spend a lot of time doing over the past, let me see if I can get this right. The past decade is to help computer scientists and lawyers more effectively interact with each other on these topics around fairness and discrimination. And so the work I'm going to present today is actually a new law review paper. It's available online. You could look for it by just searching for the title of the paper. And it's basically trying to take a relatively simple observation that's been made in computer science and explain how it really should change the way we think about discrimination law in the United States. I should really stress too that I am fourth author on this paper, so I'm acting at best as a representative for many other folks. Emily and Logan really did the bulk of this work, and they deserve a lot of the credit. And any issues that you might have with the paper, I'm sure, are mine. Okay, let me jump into it. Can I get this to work? No.
They're not synced, so when you click
I see.
These,
okay. Sorry.
If you want, I can just go to next slide for you and make sure that they are showing correctly here.
Sure.
It's up to you.
Yeah, okay.
Sorry about that.
No.
So sorry.
And sorry, just to make sure, I keep on getting a kind of like error message from Zoom on this machine. Is that an issue? No. Great, okay, sorry. Okay, so I'm gonna advance to the next slide, hopefully. Oh wait, I have to. Okay, great. Okay, so for those of you who might not be familiar with discrimination law, in the US, we have sector-specific discrimination law that regulates particular kinds of high-stakes decisions. So we have Title VII, which is the employment discrimination law. We have the Fair Housing Act, which applies to housing, and we have the Equal Credit Opportunity Act, which applies to lending. And there are, in fact, important differences between these different laws, but at a high level, they share certain things in common. And in particular, they follow the same kind of doctrine. So we have disparate treatment, which is the kind of intuitive idea you might have about discrimination, which is that someone is purposely taking into account something like your gender and treating you less favorably on purpose, intentionally. In contrast, the law also has this notion of disparate impact, which is what is being highlighted here, which is that you might make a decision on seemingly neutral grounds that nevertheless results in a disparity along the lines of gender. And the question then is that justified? And so the way the law has developed in the United States is a three-step test. So to bring a claim of discrimination using the disparate impact doctrine, you would first have to establish that there's some decision-making process that in fact does result in some kind of disparity in outcomes. So let's say the hiring rate between men and women is substantially different. And so establishing that fact is often enough to initiate the lawsuit. But then the defendant, so in this case the employer, has an opportunity to defend itself, and they can do that by saying that the criteria that they're using to make the decision are legitimate and that they serve some legitimate business goal. So this is a way of saying that, yes, maybe there's some disparity in outcomes here, but it can be explained away on the basis of these legitimate factors. But there's this final step in the doctrine, and this is what we focus on in the paper, which allows the plaintiff, so the person bringing the lawsuit, to point at an alternative that would have served the employer's goal as well, equally effectively, but would have had a less disparate impact. So that could be something like a different hiring procedure that would have resulted in a similar composition of equally qualified people, but would have had a less disparate impact along the lines of gender. Okay? Now in practice, this third step in the doctrine is rarely reached. There's very little case law on this. It's sort of like a backwater within the law because most people are not able to get to this stage in the process. They usually are unable to even establish that there was a disparate impact, and most of the time businesses can come up with some justification. So this third step is just something that hasn't really been exploited very much. But what I'm going to try to point out in the first couple of minutes of this talk is that this final idea about how plaintiffs can succeed in discrimination cases has a remarkable correspondence to an interesting idea in computer science. And that's the idea of multiplicity. So next slide. Thanks. So multiplicity refers, well, I should say multiplicity has gone by many different names. So authors have been working on this for at least 20 years, and it has been described using different terms. Leo Ryman was perhaps one of the earliest, and he referred to this as the Rashomon effect. If you're familiar with the movie, this is the idea that you can tell a story from many different perspectives. And the term here was meant to say we can develop models that are all trying to model the same exact thing in the world, but maybe are looking at it slightly differently. And for Leo Ryman, he was sort of saying that all those models can achieve similar levels of accuracy. They're just sort of telling the story in different ways. And this idea has also been picked up more recently by people who are interested in fairness in particular. And so there's been a series of papers on predictive multiplicity, which is another name for this. And all these things sort of amount to the following, which is that for any given prediction problem, there are almost always multiple possible models that we can build that will achieve equivalent performance. So we can have 100 models that all achieve 90% accuracy. It's not like there's only one model that can achieve that level of accuracy. And so this degree of flexibility is actually very important. Let's see, sorry. Okay. When it comes to thinking about discrimination law, and I'll try to explain why now. So next slide, please. In a very nice paper from a number of years ago, David Lehrer and Paul Ohm have a kind of primer for legal scholars who don't know very much about machine learning. So they kind of explain to a legal audience all the subjective decision making that goes into developing a machine learning model, of which there is a huge amount. And in fact, we've probably heard a fair amount today about all the kind of choices that people can make that might result in all sorts of different impact when the model is finally deployed. And in this paper, they say that legal scholars have tended to take what they call a naturalized view of machine learning, in which it's assumed that there is some unique solution to any given prediction problem, that there's only one model that we're going to be able to train that's going to achieve this level of accuracy, and that the task of a computer scientist or an engineer is to just apply objective measures to discover this, unique solution. And of course, what this article does, and others have done as well, is to kind of point out that there's a huge amount of subjectivity here, and that there is not, in fact, this one unique solution. But if you held this view, if you bought into this way of thinking, you might believe that there is this inevitable trade-off between fairness and accuracy, in the sense that if I can only achieve this level of accuracy using one model, then any change from that model necessarily would mean foregoing some degree of accuracy. But of course, this trade-off is not inevitable in many cases. And what we're trying to point out in this paper then is that multiplicity sort of upends the conventional wisdom within the law, because it's possible for developers to discover a range of models that perform equally well, but end up making different predictions for the same individual. So for example, one credit scoring model might predict that I will repay, and another credit scoring model might predict that I will default, but both models might be equally accurate overall, right? And what that might mean at the aggregate level is not just for me as an individual, but for entire groups of people, models that all achieve the same level of accuracy can end up making quite different decisions for different groups of people. And this is the thing that we're going to exploit to try to reduce disparate impact. And I think another thing that's very important to sort of recognize here is that if you just develop a model to achieve maximal accuracy, and you don't consider the fact that there might be many other models you could develop that achieve similar accuracy, it's extremely unlikely that by chance the model you develop is going to be the one that happens to have the least disparate impact possible, right? This is just not something that sort of automatically happens. We have to take special efforts to exploit multiplicity to find that model that is equally accurate, but has less disparate impact. And so what this ultimately means, this is sort of the punchline for our argument, is that often with reasonable and relatively modest efforts, companies can often reduce disparate impact without having to compromise their business objectives. And to give you a little bit more intuition, maybe this is clear to some of you, but I'll try to explain this. So, why does multiplicity exist? Why is this even possible? Well, you can take a very simple example. Imagine we have 10 different models that are all 90% accurate, and they're making predictions about 10 different people. In each of these models, the specific person who is subject to the error could be different, even though, again, only one person out of 10 in each case is being subject to an error. So multiplicity is just trying to point out that, like, look, consistent across all these models, we have the same degree of accuracy. It's just that where the error is located is going to be different. And we can do this at the group level as well. So it will be hard to interpret this, but this is basically showing that one model that is 80% accurate might be 100% accurate for men, but 60% accurate for women, whereas another model, which is also 80% accurate overall, might have equal accuracy across groups. And so we can kind of see this not just at the individual level, but at the group level. Okay. And so you might wonder, well, how do you train models that all achieve similar accuracy but have differences in their behavior? Well, this originates from the fact, as I was mentioning earlier, that the process by which we develop these models involves a bunch of subjective decisions. So you can think of different choices you can make along the machine learning pipeline, which is represented, next slide, which is represented here. And to give one concrete example, you can think about, again, maybe a credit scoring model. It may be that the credit scoring model uses a set of factors that come directly from your credit file. And so if anyone has ever gotten their kind of credit report, you'll know there's a kind of set of features that are included. But you might also know that lenders have begun to explore alternative data. They are using different kinds of data to see if they might be able to improve accuracy. And so one possibility might be that you develop a credit scoring model using different data or a different subset of the data that again achieves the same accuracy as you would have using your credit file, but is going to do so in a different way. And so even though these models, again, are equally accurate, let's say, at predicting repayment, they're going to be making their decisions in a different way because they're using different features, and that is likely to result in differences in who are subject to different kinds of errors. Okay. So this seems very promising. It seems like this kind of exciting insight that I think lawyers and hopefully regulators will want to try to push people to take advantage of. But there are some challenges here, and a lot of that has to do with the fact that it's not straightforward to harness multiplicity for this purpose. So to begin with, it's often not clear a priori which interventions in this pipeline I just showed you are those that are going to be most effective at finding an equally accurate model that happens to reduce disparate impact. There's a sort of indirect relationship. We have maybe some intuition that if we change these features, maybe it will be equally accurate and affect disparate impact, but there's not often this clear correspondence. It also means that the people who are developing these models have to expend additional resources. It's not like you just train a model once and you're done. This will often mean that you have to train many models to discover the set of models that are all equally accurate. So it's not something that comes for free. There's additional effort and resources that need to be invested. And finally, there are going to be limits to how much we can achieve with this. So for example, if the accuracy rate of the model is very high, like let's say it's 95% accurate, and the disparity between groups is enormous, there's only so much error that we can shift around to try to close that disparity, right? So there's just ultimately going to be some limitations to how much we can leverage multiplicity to reduce these disparities. And even so, it's pretty clear from the empirical work on this topic that there are simple, inexpensive interventions we can make in the modeling pipeline that will allow us to discover these things in practice. Okay, so let me try to be a little bit more precise about this idea of less discriminatory algorithms. This will probably be pretty obvious at this point, but we try to pin down a very specific definition in the paper. Sorry, this Zoom thing keeps on popping up. Great, I think we're on the same slide. Defining an LDA, is that right? Yes, thank you. Sorry. Okay, so we define this to be algorithms that are comparable or equivalent in performance to some baseline model, right? So here, you can say like the original model we trained, the best accuracy we could achieve was 90%. So we want an LDA, a less discriminatory alternative, to be similarly 90% accurate. And additionally, it should be less discriminatory than that baseline, right? So if the original model had, a 20% disparity, we're hoping that it will have a smaller disparity than that. Next slide. In the literature, the technical literature, sorry, I keep on getting Zoom errors. Are you sure there's nothing for me to do here? Okay. Okay. Yeah, okay, sorry. So in the technical literature on multiplicity, they actually have some discussion of what it even means for things to be equivalent. So in practice, you might say, like, strictly speaking, a model that's 99% accurate and a model that's 98% accurate are different. One is more accurate than the other. But in practice, if you're actually using that model to make decisions, that 1% difference might not actually translate into any meaningful difference in practice. And so in the literature, equivalent often is within some bound, within some range of difference. And so what that often is taken to mean is that for any particular application of this model, we're going to set some threshold of difference that is essentially practically equivalent, and that will vary depending on the decision we're making. But in practice, this could be decently large, like 5%, 10% difference may not translate into much difference in practice. And so when we say equivalent, what we really mean is within this bound of acceptability for the particular domain in which the model is being used. Next slide, please. And in the paper, we really stick to this strict definition. And you might ask, why are we committing ourselves to this situation where the model has to be equally accurate and less discriminatory? Couldn't we also consider these other possibilities? Like maybe we want to push companies to develop even more accurate models, which has the benefit of possibly reducing disparate impact. Or maybe we want to even say that in some circumstances, it's acceptable to forego some degree of accuracy in the service of reducing disparate impact. And we actually think that the law allows for those interpretations, and we would even support those. But what we want to try to show in the paper is that even with the strictest definition, the one that kind of confines us to the least amount of latitude, there's still a lot that we're able to do. So even with this kind of first definition, we can still have a lot of room to maneuver. Next slide, please. Okay, so now I'll spend a little bit of time actually talking about the law. That was sort of like the technical part, as technical as it's going to get. But Logan and Pauline, who did a lot of the legal analysis, kind of reviewed both the legislative history behind a lot of these discrimination laws. They looked at the case law. As I mentioned, there are not many cases that actually get to the stage of relying on the third step in the disparate impact analysis. But there is enough to kind of begin to draw some lessons. And there are messy lessons, but there are some interesting lessons. So let's start with that. So next slide, please. So it seems that there are four things that we can sort of say from the case law. And this is, what does the law even see as a less discriminatory alternative? What constitutes a less discriminatory alternative? So to begin with, case law seems to suggest that it is not enough for a plaintiff to point out some hypothetical, speculative alternative. They can't say like, one could develop this alternative. They need to actually point to something concrete. So there's a sort of expectation of specificity, like you're pointing to a real deployable alternative. There also needs to be evidence that this alternative will in fact reduce disparate impact. So again, this can't just be a sort of hope that perhaps this alternative will reduce disparate impact. There needs to be some evidence that supports that claim. How much evidence, what evidence is quite varied across the case law. But again, there's a sense that it's not enough to just say it could. Interestingly, the standard across the different discrimination laws and even within the same discrimination law case law has quite different theories of what constitutes equally effective, in the sense that like the terms actually vary. So in some cases, the language is equally effective. In other cases, the language is approximately equally effective. In other cases, it's comparably effective or serve the same purpose. And so the law is not giving us some clear, very precise definition here. But nevertheless, as I said, we, for the purposes of the argument, stick to the kind of stricter definition, even though the law has sort of been a little bit all over the place. And finally, when contemplating whether this proposed alternative is viable, courts have generally allowed that costs matter. So like, I can point out that there is this alternative credit scoring model that you could use, but maybe it would cost, thousands and thousands of dollars more to develop, or maybe each individual decision I would make with that model would be much more expensive than the one I'm using right now. Courts have allowed that those kinds of costs can actually cut against the argument that this is a viable alternative. So costs are recognized as important. Okay. And this is sort of like the best that we're able to do from the case law, which kind of shows you that there isn't a lot of precision here. Next slide. The other thing we also wanted to do is sort of understand who bears this burden, in the sense of who is the person who's responsible for pointing out this less discriminatory alternative. So as I mentioned at the start, it's often perceived as the third step in the process where the burden falls to the plaintiff, the person bringing the lawsuit. But the history of discrimination law actually is quite surprising in the sense that early on in the 1970s, there were a series of cases which suggested that searching for these alternatives, these less discriminatory alternatives, was an expectation that courts had of defendants, so in this case, of employers. So if you might remember, in the second step of the disparate impact test, the business, the employer that's being sued has the opportunity to defend the disparate impact by saying that there's some justification. And in this early period, in the 1970s, the courts were saying that actually, to defend itself, they actually had to show that they had spent some time trying to consider alternatives. And so the burden of considering these alternatives actually in this early period thought to rest in part with the defendant, not just the plaintiff. Okay, I'll skip over some of the next stuff because it's probably a little bit too in the weeds for the law. So maybe advance 2 slides, please. One slide back, actually. Yes, thank you. Okay, so I'm not even going to ask you to read this, but what I was just describing a moment ago was around case law. Here, we also went and looked at what federal regulatory agencies have done on the topic of less discriminatory algorithms. And here too, agencies that have authority for enforcing discrimination laws have also made statements over the years that essentially suggest that perhaps this burden also rests with the defendant, that it's not exclusively something that the plaintiff has to actually do. Next slide. But there has been this kind of slow movement over time to push this burden exclusively to the plaintiff. And in fact, in 2013, so HUD, who enforces the Fair Housing Act, basically said that definitively, at least under the Fair Housing Act, the burden of pointing out this alternative rests with the plaintiff. And the argument that was made then is that they thought it was unreasonable to expect employers to have to prove a negative, right? That they've done everything they possibly can to like explore whether there are alternatives and they haven't been able to find one. They found this to be a kind of unreasonable expectation, unreasonable burden. And you might have some sympathy for this argument, right? Because if we're talking about like some very complex process by which you're determining where to build houses, or you're trying to think about, very challenging ways of developing plans for housing in general, the expectation that people consider radically different ways of approaching that doesn't seem like a reasonable thing to do. Next slide, please. But what we're going to try to say here is that a lot of those arguments that seem to cause the courts and the agencies to sort of move the burden toward the plaintiff, I think are sort of undermined by multiplicity. So that's what we'll focus on here. So next slide. Basically, what we're trying to do is say that multiplicity really is an argument for why the burden of searching for these alternatives really should rest with the defendant. And we make this argument in a couple of ways. To begin with, we point out that across all the discrimination laws we have, each of them makes reference to this idea of need or necessity. So the justification for a business practice that has a disparate impact is thought to be something that is necessary or needed. And so it's hard to kind of say that you need to use this model to make this decision if you could use an equally accurate model that would have less disparate impact, right? If there exist alternatives that are equally effective but have less disparate impact, it's hard to claim that the one you've chosen is necessary. Next slide, please. Additionally, we know from decades of empirical work, but we also probably know just intuitively that plaintiffs are very poorly positioned to bring these kinds of cases, right? They're not going to know they've been subject to discrimination. They're not going to have the resources to do a thorough investigation. They're not going to be able to build these models that they're going to have to then propose as an alternative, right? Everything is sort of stacked against them. But you might have thought that like even a well-resourced plaintiff might still struggle to find these alternatives. What multiplicity tells us is that we can almost always assume that there is a less discriminatory alternative. It's simply something we can take for granted. And if that's true, then it's really not a question of whether this alternative exists. It's whether the plaintiff has the wherewithal to find it. So it turns a question that previously felt like, okay, maybe it exists, but we can't say for sure. And so for that reason, it seems unreasonable to require the defendant to do all this work. Multiplicity says you can safely assume this exists, and it's just a matter of spending enough resources. And so this turns this kind of third step of the disparate impact doctrine into purely a question of resource capacity. It's not if, it's just only if you have enough resources to actually achieve it. And so I think from my perspective, this is one of the strongest arguments for why we really should be putting this burden on the defendants, because they are much better positioned to actually do this search. They have direct insight into the policies that they're developing. They have ways to intervene in the machine learning pipeline. They have the expertise. It just makes a ton of sense. Okay, next slide, please. And as I was saying, right, like this sort of gets around the concerns about proof it a negative, right? There isn't any longer this uncertainty as to whether the LDA exists. And there's a structured process for finding it. So if you know anything about the way machine learning models are developed, it's already this very exploratory, iterative process, right? People tinker, they see how the changes they have made to the process result in changes in model performance. There's a natural way to keep track of how ways of intervening in the pipeline result in different model behaviors. And so this is a very structured process that can be exploited already. Additionally, we have very standard ways of quantifying model behavior, right? We can evaluate its accuracy, we can evaluate its fairness using different measures. And so we can do direct comparisons between alternatives. This is a much more straightforward way of comparing things than this open-ended policy-making process where maybe, you're comparing how an employer and a bureaucracy went about making decisions, and who the hell knows what an alternative would have been, an alternative bureaucratic procedure. Here, it's a very strictly structured process that allows us to make easy and direct comparisons. And so it just is a much more straightforward and much less obtrusive way of kind of expecting people to go about things. Okay, next slide, please. Ooh, okay, sorry, I guess I didn't keep up. Next slide after this one. Right. Okay, so hopefully I've tried at this point to persuade you that this duty should rest with the defendant. And if you believe this, you might ask, well, how is this duty going to be operationalized? What does it mean for companies that are using these models to actually abide by this duty? And so we try to develop some more specific guidance here. So next slide, please. So there's some basic requirements, and by basic I mean that like these things need to be done for the duty to be fulfilled at all. If they are not done, we sort of assert that the defendant should automatically lose these cases. And so if you step back and you think, how is it even possible to find these less discriminatory models? Well, there's certain things that you need to do. So to begin with, you need to have some kind of process for collecting or inferring the demographic information that you need to perform a disparate impact analysis, right? So if I'm developing a credit scoring model, but I don't know anything about the demographics of the people I'm using to train the model, I can't determine whether or not that model is going to have some disparity along those lines. So we have to collect this information, and this is a non-trivial issue, and I can say a lot more about that. We also need some process for actually even performing the disparate impact analysis itself, which again brings on board all the questions we might have about which are the right fairness measures, which I can say a lot about, but just bear with me. There also needs to be some process for searching for these alternatives, but in particular, we think that there needs to be some kind of process whereby people have to document when they have brought the search for a close, brought the search for an alternative to a close, right? Because we're sort of expecting that they search, but that we're not expecting them to spend an infinite amount of resources searching. And so what is the point at which they feel like they have done enough and they have to document that? And finally, there should be some process in place for actually adopting these alternatives once they have been discovered. And as I say at the end of the slide here, our view is that like if any of these things are not in place, if the companies refuse to disclose details about them, they should just automatically lose the case. That's it. There's just no reason to give them any leeway here. Next slide, please. Having said that, even if you met these kind of basic requirements, there's still the chance that the way companies go about this is not terribly thoughtful, not terribly effective, right? So they could be sort of not very careful in the way that they orchestrate the search. They cannot devote what feels to us to be sufficient resources to it. There's just many reasons why, even if they fulfill those basic requirements, it could still be something that we see as being, insufficiently careful, an insufficient investment of resources, etc. And so in light of that, this additional thing we expect is that we want companies to take reasonable steps to search for these alternatives, where reasonable would be determined by how expensive these kind of searches are, the current state of evidence-based best practices, and the severity of the disparate impact at issue. And I'll say something about each of these. So next slide, please. I mentioned earlier that costs count in determining what is a less discriminatory alternative. Courts in general have been willing to acknowledge that significant costs means that that's no longer a viable alternative. But courts have also allowed that some amount of cost is acceptable if that results in a meaningful reduction in disparate impact. And so we can rely on that same reasoning to say that courts probably think it's reasonable to expect covered entities, legally covered entities, to spend some amount of money searching for those alternatives. And so here we're sort of imagining that, there's some way that we can kind of think about what is a reasonable amount where it's no longer kind of this cost prohibitive activity for the covered entity. Next slide, please. And you can think of cost in a couple of different ways. I mentioned these also earlier. One way is performance costs, and this is the way I think traditionally we think about the costs of a fairness intervention. We think a fairness intervention is going to reduce the accuracy of the model. And by stipulation, we're saying, no, we're only focused on models that achieve the same accuracy. So there's no performance cost. That's just not a cost that even factors into this. Instead, we're focused on these development and administrative costs. It's the cost of finding the alternative or the cost of using a model that might be more expensive to just deploy in practice. And so, really, what are the reasonable costs that we think companies should bear? Next slide, please. And so we have two easy answers to this question. One should be that firms aren't allowed to invoke sunk costs. And so this is actually something that legal scholars have recognized for many decades. Like, you might imagine an employer, really kind of goes down this stupid path of developing some process for assessing applicants that if they had even thought for a moment, they could have done a much better job. And the fact that they invested a bunch of time and money in this horrible process of developing this horrible process should not allow that employer to defend itself and say like, well, I've already spent all this money. How could you expect me to go back and start from scratch? So the first answer is that like sunk cost is not a defense against this stuff. The second thing, and this is cheating a little bit, is that firms really should be investing in reducing disparate impact that covers its own costs. And so here, the way this is most likely to be achieved is that I can spend money, for example, on collecting a bunch of additional training data, and that might end up improving the accuracy of my model in ways that reduce disparate impact. And so even though I've spent money, it's possible that I make more money, or I make at least as much money to cover the cost I spent trying to collect this additional data. And so this is a little bit of a cheat because here in this case, accuracy is going up, it's not equivalent. But the argument anyway would be something like, there should be this expectation that any investment in improving the model that covers its own costs should be something that firms are expected to do. Next slide, please. And then, the more I think, hard, the slightly harder arguments to make are the next two, which are, we also think that the state of the research on these topics is evolving, and the tools that are readily available to companies are also changing over time. And so, we want the law to kind of keep pace with the state of knowledge and the state of practice. And so we think it's reasonable to expect that firms follow evidence-based practices, that are kind of determined to be effective by independent research, and that kind of experience suggests are possible for firms to execute. And you might think this is a very hand-wavy standard, right? Like, is this sort of just like the industry can decide not to do anything, and that's fine because no one else is doing anything? And I think the idea here is that we basically want to have a standard that catches out actors who are really not doing things in step with their competitors, right? So we don't want to let anyone save money by doing, by not doing the thing that their competitors are doing. So this is a way of kind of keeping that in place. And finally, we also think that the larger the disparity you're trying to close, so for example, if you're building a credit scoring model and the selection rate is vastly different across racial groups, that difference in selection rate, if it's big, justifies an even greater investment in this search. Okay, next slide, please. So I'll talk about a few caveats and possible objections to this, but I also want to mention that two of the people who are on this paper work at an organization called Upturn, which is based in DC. It's an organization that provides often kind of technical advice to civil rights groups. And they were involved in a legal monitorship that was initiated by the NAACP with respect to Upstart, not to be confused with Upturn. Upstart is an alternative lending company that specialized in student loans. And part of the information that they consider were like student grades, so like how well people were doing in school. Quite recently, a lot of civil rights groups were concerned that given disparities in the way that students might be graded, that there was going to be a racial bias in the models that are being developed on that basis. And so Upstart voluntarily agreed to enter into this monitorship, which meant that they would bring in some outside folks to evaluate whether in fact these models did in fact have a disparate impact. It turns out that they did, so there was actually evidence to support the concerns. And then the next step was, could there be a way of finding a model that was equally accurate, achieved like the same performance that had less disparate impact? And they brought in some statistical consultants who in fact were able to find these alternatives. So they were able to identify two models that were kind of comparable in the performance that reduced disparate impact for Black and Hispanic applicants. And so the folks at Upturn, not Upstart, who were involved in this monitorship, saw this as like a very promising real-world example of the promise of multiplicity. And so a lot of the work was sort of trying to develop a legal theory to support what they had already kind of achieved in practice. Even so, there are some important caveats, and that's what I'll talk about now. So next slide. So one is that there can often be context-specific reasons to favor a more precise definition of performance. And what I mean by that is, I've kind of been quite hand-wavy throughout the talk where I just say performance or accuracy. If you're a lender, you probably care very much about the type of error you're making. So it's probably a lot more costly to lend to someone who defaults than to fail to lend to someone who would have repaid, right? And so the cost of those errors are not going to be symmetric. And so there might be a reason to favor a more precise notion of performance. And even so, even if we have a more precise definition, multiplicity still applies. The amount of models that we'll be able to find when you have more and more precise or more and more specific constraints on your performance metric, the total number of models you can find will become smaller, but you'll still be able to find models of equivalent accuracy that's disparate impact. We want to allow for the possibility that firms have legitimate reasons to favor this, but our argument here is to simply say that they have to justify those reasons. They can't have arbitrary reasons for favoring some specific notion of performance. They have to be able to say why it is that they actually care about this. And one reason might be, as I was saying, in lending, there are differences in the costs of errors. Next slide, please. The other thing we also want to be really careful about is that this paper is ultimately really making an extremely modest suggestion. Many of us on this paper have, I think, far more radical views about what would be a way to address a lot of these problems. And this paper was sort of like a pragmatic attempt to work within the confines of the law as it exists. So we're really trying to make an argument that fits very well with the existing doctrine, right? It's not some radical departure. At the same time, we are fully aware that this is not a cure-all. So like, simply trying to find these models that are similar accuracy but have less disparate impact, like there's only so much that's going to be achieved by that. And so in many cases, even after having done this search, the accuracy of the model still might be ridiculously low, right? It just might be so low that we would think it's totally inappropriate to deploy that model. Or maybe, you know, the disparity continues to be significant even after you've spent a lot of time trying to break it down. So our argument here is not to say that like you do the search, you've expended reasonable effort, now you're okay. There's still going to be situations where this is not acceptable. And we sort of further reinforce this by saying that businesses still need to justify the way that they actually go about building this model in the first place, right? So if they just done a really bad job building the model, they're going to have a hard time justifying that to begin with. Another thing we kind of point out is that even though we hitch a lot of the argument to this idea of accuracy, accuracy is not a particularly stable or reliable metric, right? So, you know, we train a model on historical data. It seems to do pretty well for like the first couple of months that we have it in deployment, but the world changes. And so the performance of the model doesn't kind of keep pace. And so we should also be really attentive to the fact that there are reasons why we shouldn't have so much faith in accuracy. We also heard things earlier today where maybe the training data we're using is itself kind of infected by past human prejudice. And so the labels we're using to train the model are not representations of how things actually played out, but the kind of biased assessment that humans made. And so in those cases, like you can build models that accurately predict how human biased decision makers would have made decisions. And that's accurate, but accurate not in the sense with respect to reality, but with respect to these biased decision makers. So again, we're well aware of the dangers of relying on accuracy. And we want to ensure that these things are also addressed in the other parts of the legal process. And finally, as I said earlier, we adopt this stricter notion because we want to say that even in the stricter kind of notion of equal accuracy, you can do a lot. The law, as we found it, could support a kind of more expansive idea about what counts as equally effective. I think I can probably stop here, or I can go to the next slide. It's really up to you. Yeah.
We have gone through the time we allocated for this talk. So by the way, we want to make sure we have time for a few questions. So maybe we take 5. Oh, let's give a round of applause to our speaker. And maybe 2 short questions. Alicia.
Hi, yeah. So we're getting to the point where very large models are becoming the norm. So I see that model multiplicity would work very well for retraining small models, but when you have a large model, what would you do?
Yeah, this is a great question. Exploiting model multiplicity means having to train many models, right? So if training even one model is expensive, it becomes quickly like not feasible to train many expensive models. So I have a couple of answers to this. To begin with, in a lot of the domains covered by discrimination law, I still think we're in the kind of like small model regime, right? We're using like tabular data. Maybe we have like on the order of tens of thousands of training examples. And so I think for a lot of these kinds of decisions, at least for like, you know, maybe the next 10 to 20 years, I still expect that we're going to be in the regime where it's possible to train many models. Additionally, I'm working with some other folks not on this paper who are developing more efficient methods for doing this kind of work. And even in the kind of like regime of these large models, so like an LLM, for example, although it's not obvious to me what it means to say that LLM discriminates, but yeah, even in that case, there's some ideas that people have for how to like exploit structures in the optimization process that allow us to maybe still train more. But the point is well taken. There are going to be situations where if we're really talking about large models, it won't be possible to train a large number of them.
Any other questions?
You alluded to this before, but I'm curious, even in a case where your LDA has super high accuracy and super high fairness, depending on however you're choosing to measure fairness, is there wiggle room in the multiplicity argument to talk about the input data, the outcome you're measuring, like other ways that this argument might potentially be flawed?
Yeah, that's a great question. So I think many of us on the paper have written earlier work that like identifies all the other parts of the modeling pipeline that you might intervene to just generally try to address concerns with discrimination. So we all believe in that stuff. multiplicity in general has been taken to mean like that we assume a fixed target of prediction, and then we have a lot of like freedom to intervene in the other parts of the process. But in some other work that I've been involved in and other people have been thinking about too, is like we could even consider like multi-target multiplicity. Like, there's no one way to possibly like formalize what it means to default, for example, right? Like, is it you fail to repay after 6 months, 9 months? Like, there's no like one way we would define the target. And so even that is possibly a point of intervention. But yeah, it's interesting to kind of think about like the degree to which you can expand the set of things that you would want to intervene in a formalized way. Yeah.
Terrific. Maybe one more short question if we have one. All right, well, let's thank our speaker again. Thank you so much.